Welcome back. If you've ever wondered how the gears of justice actually turn once a dispute hits the legal system, well, you are in exactly the right place. Today on The Explainer, we're taking a highly focused, step-by-step journey through the life cycle of a civil lawsuit under the Civil Procedure Code, or the CPC. We're going to completely strip away the confusion and look strictly at the procedural framework that dictates exactly how a civil suit proceeds, literally from the very first filing all the way to the final decree.
Okay, let's dive into this by mapping out our roadmap. We've got 5 distinct chronological stages here. First, initiating the lawsuit. Second, the defense response. Third, framing the issues. Fourth, the trial phase. And finally, judgment and decree.
Let's start right at the beginning with Section 1, initiating the lawsuit. To kick things off, we really need to understand a critical piece of legal terminology, and that's the plaint. Think of it simply as the formal complaint. It's the foundational document of any civil suit, drafted under Order 7, Rule 1 of the CPC. This document officially starts the clock. It has to be presented along with a concise statement of the claims to actually spark the whole judicial process into action.
Once that plaint is presented, the court does some immediate checks. They essentially play bouncer here to make sure the case actually belongs in their system before they even bother the defendant. So, step 1 is presentation. Step 2 is absolutely crucial, checking jurisdiction. The court has to confirm it has both the financial and territorial authority to hear this specific case. If it passes that test, step 3 kicks in, issuing summons against the defendant. The ball is now officially in their court.
And that brings us to Section 2. The defense responds.
The vehicle for this response is called the WS, or written statement. This is the defendant's formal written counterpunch to the claims laid out in the plaint. At the direction of the court, under Order 8, Rule 1, the defendant has to officially submit this document to put their defense on the record.
But, they don't have forever to do this. The procedural framework is incredibly strict, but it does treat different defendants quite differently. A private defendant gets exactly 30 days to present their written statement. But what if the defendant is the government? Well, that deadline triples to 90 days. I guess the law knows navigating government bureaucracy takes a bit of extra time, but either way, that clock is ticking.
Moving right along into Section 3, framing the issues.
Before the court can officially identify the core issues of the dispute, they do something highly practical. Both the plaintiff and the defendant are brought in for an oral examination under Order 10, Rule 1. Why? To officially record their admissions. By doing this early on, the judge can immediately weed out what the parties actually agree on, isolating exactly what they're fighting over. It's kind of like clearing the smoke before the battle.
This leads to a massive shift in power from the parties straight to the judge. Taking into account the written statement and that oral evidence, the court steps in and explicitly frames both the legal and the factual issues. Then, they officially shift the burden of proof. The battlefield is now completely mapped out, and everybody knows exactly what they need to prove.
With the battle lines drawn, we enter Section 4, the trial phase.
So the crucial point here is the number 7. The system absolutely does not let things drag out once those issues are framed. Parties have exactly 7 days under Order 16, Rule 1 to file their list of witnesses and documents. That's just 1 week to formally declare exactly who and what you're bringing into the courtroom to back up your side.
Right after that tight deadline, the actual evidence is led. Usually the plaintiff goes first, simply because, they brought the suit. However, there's a really interesting exception under Order 18, Rule 1. This sequence actually flips if the defendant admits to the facts alleged by the plaintiff. So the flow of the trial dynamically adapts based on those early admissions. And those strict deadlines, they just keep coming. Look at this number, 15. Once the presentation of evidence is officially terminated, the court can't just sit on the case. The court is mandated to fix a date, not exceeding 15 days from the end of evidence for hearing the final arguments of the parties. The pressure is really on to wrap up the trial phase rapidly and decisively.
Which brings us to our final act, Section 5, Judgment and Decree. Let's look at what actually comes out of the court first, and that's the judgment. The court is required to state its decision on each individual issue we talked about earlier, along with the specific reasons for that decision. It is a highly detailed statement. The judge doesn't just say who wins, they literally explain the underlying logic for every single point of contention and frame the points for determination. Now, a lot of people tend to confuse the judgment with the decree, but they are very distinct. While the judgment contains all the deep reasoning, the decree is the official, operational order drawn up afterward.
It's the formalized legal instrument that actually gives effect to the judge's decision.
And this brilliantly illustrates the exact relationship between these two documents. The rules are crystal clear. The decree must be in total consonance or complete agreement with the judgment. No way around it. It cannot invent new remedies or contradict the written reasoning. They have to align perfectly to faithfully execute the judge's logic.
And here is the final, incredibly strict deadline of our journey. This operational decree must be drawn up within exactly 5 days from the date of the judgment. No lingering, no endless waiting for paperwork. The system demands that the final binding order is produced practically immediately after the judge's decision is read out.
Let's step back and see how this all builds into our final sprint. Look at how rapidly the end of a lawsuit is designed to move. On day 0, evidence ends. Within a maximum of 15 days, arguments are heard. Once the judgment is delivered on day X, the court has a mere 5 days to draw up the binding decree. The whole machine transforms from this careful evidence-gathering procedure into a rapid-fire decision factory. So as we wrap up, we're left with a truly fascinating question. We've traced this strict chronological life cycle of a civil suit, complete with 7-day, 15-day, and 5-day deadlines. Now, it is so easy to view all of this as just frustrating red tape. But considering how these rules force everyone, private parties and the government alike, to act swiftly and lay all their cards on the table, how might these rigid, ticking clock deadlines actually be the ultimate safeguard for ensuring true fairness? It certainly makes you view procedural law in a whole new light. Thanks for joining me on this explainer, and keep questioning how the systems around us really work.